I got to
Good?
sit down
Okay.
and talk about things success. You know, because you want to be.
I think we'll be done. All right, we'll go ahead and call this meeting to order. Mr. Schron? All right, we'll go ahead and call this meeting to order, the Cuyahoga County Committee of the Whole, meeting for Wednesday, July 2nd, 2014. Will the clerk please call the roll?
Calling the roll, Mr. Brady. Here. Mr. Germana.
Here.
Mr. Gallagher.
Here.
Mr. Schron.
Here.
Ms. Conwell. Here. Mr. Jones. Mr. Jones is absent at the moment. Mr. Hairston. Here. Ms. Simon. Ms. Simon is absent at the moment. Ms. Conley. Here.
It is.
Mr. Miller. Here. And Mr. Greenspan.
Here.
There is a quorum.
Thank you. Is there any public comment related to the agenda?
There is, Mr. Chairman, Will Tarter.
Very good, thank you. Good morning. Great, good morning.
Good morning.
Thank you, Mr. Chairman, members of council. There it is. Mr. Chairman, members of council, Will Tarter, member of the Charter Review Commission, just here to provide any commentary and answer any questions you may have about the agenda today.
Great, thank you very much. No other public comment?
No, Mr. Chair.
Okay, great. Just for matter of reference, this committee meeting is scheduled to discuss proposed charter amendments that were submitted by members of council. Unlike last year's meeting, where the items we discussed were submitted by the Charter Review Commission and we could not amend them on the floor, these charter amendments we can amend and discuss on the floor here today and make changes as we see fit. The protocol, and we have 8 items. I have divided them up into 5 and 3. I believe 7 of the items we've been discussing on and off for the last 2.5 years. So the items of discussion should be very familiar to us. I've divided them up into 5 for today's meeting, 3 for the meeting on the 7th, and then the intent is that we will not vote on any items in these next 2 meetings, but that we will come back on the 17th, and if we are in a position to vote matters to the council, we will. We do have time. We don't have to have these items submitted to the Board of Elections until September 5th. The current schedule would be to vote them out on the 17th, if any are to be voted out, be placed on the next council meeting, which will be the last meeting in September, for second reading and third reading, the first meeting in July. First meeting in August. We still do have an extra meeting in August if we needed additional time. So we have strategically planned these out to give us ample time to discuss. The first item on the agenda, and the reason that we did it this way, was because the internal auditor would like to make some comment on the first item. So we, in discussing it with staff, put these 2 items, the first 2 items we're going to discuss, which will be items, and we have an email, items Resolution 2014-0165 and 0164 are of like content, and that's why they're being discussed now. So if the clerk will read 2014-0165, and if the internal auditor would come forward, please.
Resolution number 2014-0165, a resolution providing for the submission to the electors of the County of Cuyahoga an amendment to Article 6, Sections 6.01 and 6.02, and Article 11, Section 11.01 of the Charter of Cuyahoga County, changing the composition of various county boards and commissions to ensure independence of judgment of all members, and declaring the necessity that this resolution become immediately effective.
Great, thank you. I'm the sponsor of this piece of legislation and the piece of legislation after this, and the concept between the two are fundamentally the same. It is my belief that the way some of our boards and commissions are currently structured, there is the opportunity, and if nothing else, the appearance of a potential conflict of interest when, in some of these instances, where one employee reports to the other who serves on it, and that composition itself serves as a majority of the voting block of that specific board or commission. With that said, and within 0165, there are three commissions or boards that are discussed: the Budget Commission, the Board of Revision, and the Internal Audit Committee. And so what I will do is turn it over to the Internal Auditor with respect for her time and ask her to address the Internal Audit Committee structure and receive her feedback. Is the green light?
Yeah, it's on.
Okay.
Good morning, Council and Chairman Greenspan. I think just to give you a little background of where this kind of started, the last exit conference that the Auditor of State had, there was some comments made by the senior audit manager there questioning the independence of the audit committee. And although nothing was written in the report, his questions were centered around the fact that we have the executive and the fiscal officer on the audit committee by charter. And I think his suggestion is that that those positions removed. I know Chairman Greenspan has put in a charter revision to remove the fiscal officer. I would also like to recommend that the executive is removed as well. Council as a legislative body has a seat and should have a seat. The way that it's structured now and the way that I would envision that it would continue to be structured is that the executive would still have the 4 nominations for residents that would be confirmed by council. If you go into any of the associations, the AICPA, the ALGA, which is the Association of Local Government Auditors, when you structure audit committees, all of them recommend that management is not part of those. It does not have a role in those positions. The reason being, most of what I audit, a good portion of our audits are under the executive's control, and all of them in some manner, way, shape, or form do tie back to the fiscal officer because there is such a financial component to it. So my recommendation is that along with the change that you've made here is that you consider making the change to remove the executive from the position as well.
Okay, thank you.
Okay.
And just right now, the current structure of the Internal Audit Committee is the executive, council president, the fiscal officer, and 2 residents of the county appointed by the executive, confirmed by council. Further to, and my resolution effectively, or my proposal actually removes the fiscal officer, as the internal auditor said. Her recommendation, based on feedback from the Auditor of State's office, is to remove the executive as well, and replace the executive's position with an additional resident of the county. So I'm okay with that recommendation, but I'll open it up to the floor. Yes, Ms. Kamala.
The chair, I just want to be clear, so I'm understanding why we would remove them, but who would replace? Would it be the executive? Isn't that like the executive sitting on there, even though they're appointing the members?
But council would still have that confirmation ability. So the executive, in effect, would still have a voice on the board, but would not actually sit on the board.
And
So
right,
would not have a voting power or anything on the board.
And do you know how the executive currently feels about this proposal?
No, I have not had any discussion with them on that.
currently, the executive appoints 2.
I know, but I'm just wondering if he,
Just as a point of reference, from the city of Cleveland, I think is one of the things that the Auditor of State referenced. Theirs is totally a complete separate board. Cleveland Schools is the same way. With Cleveland Schools, because you have the municipal school district, the mayor does have appointments that are confirmed by the Board of Education. So I think that the recommendation is a structure very similar to that.
Madam President.
Thank you, Mr. Chair. I think that Ms. Harry makes a good point. The audit committee is currently chaired by the fiscal officer, and the fiscal officer is in charge of basically the things that she audits. and is in charge of all of the finances, and that's what she's auditing. So you want to have a basic separation of powers. So actually, the executive actually sits, usually always sends a representative, and the fiscal officer. That's, and when there's 5 on the committee.
Right.
And so I think that based on the separation of powers argument and diversification, that it would make a lot of sense to, and comply with what she's saying in terms of other management programs to change the charter. Because these audits are really, I've really kind of gotten into this internal audit thing. This is really, really very, very interesting. And it has really raised a lot of questions. And I keep telling Valerie that I think she has a disease or something, because every time she goes into a department, suddenly somebody gets like deathly ill and leaves, or decides to retire, as soon as she shows up, with her auditors. So, we're finding a lot of little different problems here, and I think that this would definitely enhance our credibility.
Yeah, I will say at this point, we have not faced any adversity from the way that it is structured. I will say, though, probably mainly because the audits that we have recently released or are working on that are somewhat controversial have been requested by the individual. So Andrea Rocco did request us to do the clerk of courts. Although we were going into the sheriff's office because of an issue that came out of the auditor estates report, we were requested to look at some other areas there that we're currently looking at. So we haven't faced any adversity. We do have an outstanding audit with the treasurer's office that we have not had any exit conference with them yet.
And I'm prepared to work with staff and work with you, Mr. Chair, and come up with an amendment and submit it and sponsor it.
Okay, very good, thank you. Mr. Strong?
Thank you, Mr. Chairman. Yeah, and I too think that in light of all that took place prior to us, the more places that we can be as completely transparent in everything we do, and obviously internal auditing is one that raises to that level. In respect to that, the names and the location, are we limiting, and do we have to be limited, Mr. Chairman, to Cuyahoga County for any of these positions? Does it have to be?
The way the charter is currently written, 3 residents of the county
Right.
is, now, are we limited?
But we're getting ready to make a change to that.
Well, the charter, well, two concerns with that. First of all, the charter throughout talks about participation within county government as being residents of the county. If we start inviting non-residents of the county, then my concern might spread to travel reimbursements and other costs related to people coming in and meeting, and the frequency of having them available. I understand the position of identifying and attracting people who have experience beyond the county borders, but I believe, it's my belief in the spirit of the charter and being the largest county in the state that we should be able to identify qualified members.
I'm just thinking in terms of you have, we're talking regionalism and all the other aspects of it. If you have somebody right on the edge of Lake County that is the best in the country and in an area of this nature, I know that I sit on some boards, and the internal auditors on this can be sitting in Lake County, can be sitting in Geauga County, and it seems a shame to, if we're opening up one more slot, to have, if the best and brightest perhaps on this would add to that, why limit it to just Cuyahoga County if our function is to be internal checks and balances on our $1.3 billion out there. So I'm just asking the question as to whether the 4th position is mandatory. Then the second one is, does this help us in the area of providing services to other communities in doing internal auditing if we can show and demonstrate? Because that's one of the areas that I think that we as a county could reach out to some of these smaller communities that don't have the ability to do internal auditing function when we're doing shared services and support. It just seems to me this is a great outreach opportunity for us.
We certainly would like to do that. We've actually been asked to do it in one community that needed some audit work done. At this point, I just don't have the staff or the time to do that. If council and the audit committee decides that want to grow this, we can talk, because I kind of see this department as being able to keep 16 people busy with a lot of work. And so
Yeah,
we can discuss that at a later.
And right now, there's
date.
no prohibition. There's nothing that says we can't do
No.
that. So if
No.
the internal auditor was to come to us with a contract, there's nothing
Right,
preventing
there's
us from doing
nothing
that.
that says we can't, it's just that we don't have, in fact, I'm in the process of hiring 1 and maybe 2 people in this next couple weeks here. So if, we just don't have the people or the time to do it.
Mr. Germain?
In human resources, we found out at our human resource department, they keep track of how much the time is. And so when they lend a human resource person to a city, they charge them at that rate. So that might be something that we would consider.
Yeah, I mean, we could certainly be revenue generating. That's not a problem.
At break even, at what the
Oh,
cost is.
yeah, whatever our cost, whatever the cost of the audit is versus the hours that they spend on it.
My question about this audit committee is, how often does it meet? And how much time does it take?
From the audit committee by charter is to meet quarterly. With we don't have a scheduled meeting date, we just kind of set them during the quarter as need be. Ellen can probably tell you more as to how much time it takes. The meeting itself is maybe an hour or 2 hours.
Mr. Chair, this is just a little brainstorm idea. If we take the executive and the fiscal officer off and add the president of council as chairman, it might be advisable to have the finance chair of council be the second person, and then you'd still have the 3 residents, because the finance chair is going to know, have a very good feeling of what may need to be audited. So that would give you the 5. That's just kind of a brainstorm here.
From my experience with the auditor state, a lot of audit committees were set up that way, where the finance, sometimes the finance chair and sometimes the entire finance committee was actually acted in an audit committee capacity as well.
Any further discussion? Any, on this is actually just one component of this proposal. Are there any amendments or adjustments to this? Madam President, you mentioned.
Yeah, I'm prepared to work on one to submit to, and I'll take into consideration Mr. Germain's suggestion, which is, pretty good, and I'll work with Valerie, and then we'll come up with an alternative and submit it for the next meeting. Is that okay?
Okay, great, thank you.
All right, thanks.
Another component of this resolution, we'll just kind of work backwards, would be the Board of Revision. And although we submitted this, a revised composition to the electorate last year, this, in the same spirit of what we're doing with these 3 boards and commissions that are addressed in this proposal and the 4th in the subsequent proposal, this is just another opportunity for us to eliminate any perceived conflict or undue influence. So right now, the members of the Board of Revision are comprised of a member of council appointed by the president, the executive, and the fiscal officer. And this basically removes the executive, basically this says that the Board of Revisions shall comprise the county executive, an appointee of council, and then 1 elector of the county. So the fiscal officer would be removed as a member of the Board of Revision. Once again, and I think it's important as we discuss this one, and we understand the genesis of how a statutory county is structured versus a our charter form and what we have done as a practice. In a statutory county where the composition of any of these boards is 2 members of the Board of County Commissioners, which is 2 of 3, which is a majority, serve on these boards and commissions, we in this county have split that between the executive and council. So what has happened is where we've had an executive member, the executive or his or her appointee, council representative, and then the fiscal officer or treasurer or another member. Under our form of government, that member, that third member is not elected as they are in statutory counties. They're actually appointed or an employee directly of the executive. And so what we have is a potential conflict of interest there, or the appearance of undue influence. So what we're doing here with this and the 2 subsequent is just eliminating that. So the proposal before us would be to remove the fiscal officer and replace that Board of Revision vacancy with a member of an elector of the county, once again appointed by the executive, confirmed by council. So that's the proposal.
Mr. Chair,
Ms. Simon.
my comment on this is I don't support this Board of Revision component. This is a quasi-judicial body. The Board of Revision, they're making decisions on behalf of people who come in with complaints from the community. And this is judicial, this is quasi-judicial, and I'm not comfortable putting somebody from the electorate out there. And it's important, I think, to have the administration continue on with the 2 appointments to oversee this body. I think the people who created this charter had it right the first time, and I don't think we should continue to make changes to this, even in consideration of the history since we've been on in 2011. So I'm not comfortable with this particular part of your proposal.
And I appreciate that and respect that. And just so we're clear, the charter amendment that was adopted by the residents of the county last year effectively clarified some, what I would have perceived at the time of the charter, some ambiguity in what the Board of Revision versus the hearing boards were. This Board of Revision, which I currently serve on, we don't hear cases. As a matter of fact, we're not involved in the interviewing or selection of hearing boards. We basically provide oversight into the operations and policies of the Board of Revision itself. And so in the previous charter, the original charter that was presented, the Board of Revision actually were the hearing officers, and that led to some confusion. This one basically is effectively what would be the statutory Board of Revision within any statutory county, and it serves in that capacity, so we don't actually hear cases.
I understand you don't hear cases, but this is a body that oversees a quasi-judicial grouping of hearing officers, and I'm not comfortable going out to the public and bringing in an elector, somebody from the community to oversee a quasi-judicial body. I understand they're not hearing cases.
Okay, very good. Were there any other comments? Mr. McCloof, I see you.
Just a quick clarification is obviously unlike the Internal Audit Committee, which by definition is an audit committee. This is more of a managerial function in terms of what the Board of Revision does. And the way that it was amended, you have the individuals who are appointed by the administrator who hear the cases. But if you think of what the Board of Revision, the statutory board, does under our structure, a lot of it are managerial questions, and they vote on the tax duplicates. So you're basically taking the fiscal officer out of approving the tax duplicates for the county. It's almost splitting that function. Again, that may be more of a policy question, but unlike the need for independence in a Board of Revision is, on all the judicial hearings that are affecting where there's any way of influencing things, those have been segregated, and the functions that are left in the board itself are really the managerial functions, the day-to-day management of that board. They're not overseeing, or the idea of an independence. I don't know to what extent it really applies. At the end of the day, it's a policy decision, but I think it really is day and night between when you're thinking of an audit committee versus the Board of Revision itself.
So let me ask the law director, are you saying that if of the three current members of the council, the executive and fiscal officer is the more relevant of the positions of the board members?
Again, it's not a question of the fiscal officer obviously is the entity in charge of you know, appraising property and the valuation of property is a relevant member because they're, you know, they are, part of their job is to appraise these properties, and then you have, you know, the approval of the tax duplicate, what you do, I mean, that's generated by that office. So obviously, it's a relevant member. Again, the executive is the administrative branch of the Board of Commissioners. I mean, again, we're talking about the valuation of property in the county. There is you can really see a valid reason for both existing on it, representing different interests. I know one appoints the other, but one represent more the taxpayers, the one person elected countywide, another person represents the interest of that office that has done the appraisal. So they're really differing. I don't know that I view the fiscal officer and the executive as being in unanimity representing the exact same interest in the Board of Revision. And again, I'm not advocating for it or against it. I just sort of, so that council's fully, you know, by definition, this is a managerial board. This is not an oversight board, or this is performing the functions of government that we do.
Well, what I'll do is I'll work with our council's counsel, and we'll discuss this further. Maybe there, if it's determined that the fiscal officer is a more relevant member to the board because of the function the fiscal officer serves than the executive, then maybe we'll look at replacing it that way. But I stand firm in my belief that an employee who reports to another employee should not make a majority of a board. So if it's one or the other, we'll determine over the next few weeks which one is more relevant to the board.
Mr. Chair, if I can just follow up, it's an administrative function that oversees a quasi-judicial body. And given that, I want to say again, I'm going to stand firm on keeping the administration involved in the of this function. It doesn't make sense to bring somebody in from the outside to be serving on a board to manage a Board of Revision. I don't see the conflict here, and this is an administrative role that's been actually working quite well.
Mr. Chairman.
Where did that come from?
Mr. Chairman.
Mr. Miller.
I'm going to weigh in on this. I agree with the law director that this is, and with Ms. Simon, that this is essentially a managerial function to run this board, and I think it's very different from the audit commission where you really want the outside independent oversight, and I think that the concern that the chairman has expressed does not apply equally in all cases across the board, and while I have a lot of support for changing the structure on the audit commission, and would only raise the question as to whether some of the public members should be appointed by the council as opposed to all of them being appointed by the executive. We should just take a look at that. But I support the concept, however we work it out on the audit commission, but I think it's not needed for the Board of Revision, and that it actually works best to have the administration people that are really in charge of running this process to be on that board, along with a council member for some oversight.
If I may just sort of quickly, because I was involved with this when it went before the Charter Review Commission. If you remember, even when all these issues were considered by the Charter Review Commission, and there was even a change to the proposal of the Charter Review Commission that the law department and I personally pushed for very hard, which we actually put it in our charter, a ban on any discussions, any ex parte discussions between the statutory board and the hearing officer. So by our charter, the fiscal officer and the executive and the member of council are prohibited from having a discussion with any of the hearing members about any of the cases that are in front of them. They can't even have a discussion on any of those substantive cases. So we've accounted for a lot of those conflict of interest issues in the charter. I mean, that was addressed, and that was something that we put in the last amendment that it went through. And it's, you know, it says no member of the board or any of the hearing panels may have any ex parte communications with any party, elected officials, county employees, or any other person regarding the merits of a pending matter before the panel. The board shall enact and publish additional rules, procedures, or regulations to ensure that the system is administered fairly, including rules, procedures, or regulations governing conflicts of interest. So we went that far in how, and actually that was a push by the law department to take it that far to ensure the accountability and the steps in it. The portions that are left of the statutory members are really the day-to-day managerial functions of that board.
Right, and my intent, and my thought, taking that provision in mind, wasn't from the statutory board to the hearing officers. It was decisions made between the three members of the statutory board. So I'll meet with Mr. King and we'll discuss this further. Any other discussions on this provision? Okay, hearing none. The other item has to do with the Budget Commission. The Budget Commission right now, this is along the same thought, is made up of the county executive, fiscal officer, and the prosecuting attorney. Once again, the concept perception here, the fiscal officer is an employee of the county executive. The proposal will be to replace the fiscal officer with the council, I'm sorry, it's the council president, fiscal officer, and prosecuting attorney. The request here is, or the recommendation is to replace the fiscal officer with the council president and make the fiscal officer an ex officio non-voting member of the Budget Commission. Any discussion?
Yes,
Mr. Brady?
Just weighing in briefly on the three of these, rather than take the microphone 3 times. I am sympathetic to the first proposal on the Audit Commission. Details, I'd like to hear more. The Board of Revision, I don't support the proposal. I remember, and many others do, I'm sure, how far we've come with the way the Board of Revisions were set up a decade ago and for so many years before that, and how those appointments were made and how much of a patronage operation that was, and how unfortunately some people even went to the extent of interfering with the evaluation of property, and it was just really almost seems like a time far ago and unbelievable, even though it hasn't been that long ago. And I think we've come a long way on it, and I don't think we also improved upon it 2 years ago. I don't see a reason to continue to. I don't see anything left to fix here, actually, although I understand your reasoning because it's consistent. On the Budget Commission, I don't know. I don't know what the right formulation is. I do not see the prosecutor's role on the Budget Commission. So for what it's worth, those are my suggestions or my thoughts on the 3 items.
And just currently, the way the charter is written, the prosecutor is one of the 3 members. That's not something proposed to be changed. The prosecutor is currently a member per the existing charter.
This would appear to me to alter that relationship in terms of its the authority of the prosecutor on the board.
This would only replace the fiscal officer with the council president. So the executive and the prosecutor would remain. The fiscal officer would be replaced. Status would change to an ex officio member, and the council president would be placed in place of the treasurer as a full voting member. Of the fiscal officer.
Okay, well, thank you for the clarification. I still believe that, from what I understand, that this alters the the role of the prosecutor vis-a-vis the other members. So maybe I should have come at that from a different angle than the prosecutor's office.
Okay, great, thank you. Any other comments? And I'll close with this on this specific resolution. Once again, the intent here is to remove or alleviate any perceived conflict of interest or undue influence placed by an employee, could be placed on an employee by their employer. That's the purpose of at least the last two that we talked about. If there's no further discussion on this resolution, we'll move on to Resolution 2014-0164.
Mr. Chair, just a final comment to your intent. I guess we can apply that intent to any employer-employee relationship. I just want to leave the commission to think about that. I mean, just because the managerial role is overseeing a board of revision, it's consistent with any kind of administration oversight of its employees. So I'm not sure, how this necessarily would just apply across the board to every single relationship between our administration and any employee. I just want to leave it with that. I think this is overbroad, and that's my position.
Well, and what we've done, and to that point, what we asked staff to do was to review, since we're talking about charter provisions only, ask the staff to review any charter-related boards or commissions to which there very well may, where an employee reports to an employer, and the two of them sit and comprise the majority of a board or commission. That's why these three, or these two, and the next one we're going to talk about are being discussed. So does the theory hold true elsewhere? We would have to look, but that would be a matter of ordinance, not charter amendment. But it comes down to the ideology of belief that there is an opportunity for influence, undue influence, by an employer to an employee to which the two serve as a majority of a board or commission. And that's the philosophy when we looked at the charter for boards and commissions where that potential conflict existed. And the only intent between these two past provisions and the next one would be to alleviate that potential or perceived conflict. Okay, the next item, 0164, if the clerk will please read that item.
Resolution number 2014-0164, a resolution providing for the submission to the electors of the County of Cuyahoga an amendment adding Article 6, Section 6.03 of the Charter of Cuyahoga County, establishing the Investment Advisory Committee in the charter, and declaring the necessity that this resolution become immediately effective.
Great, thank you. I was a sponsor of this one as well, and I'll address this specific resolution. And I'll provide some background. By state law, investment advisory committees exist in every county in the state, and they have two different compositions. They can be 3 members or 5 members. If it's a 3-member investment advisory committee, it is by statute 2 members of the Board of County Commissioners and the treasurer. Once again, you've got a majority of the Board of Commissioners serving on the Investment Advisory Committee, or the county may opt for a 5-person commission, which would, or 5-person committee, which would comprise the 3 members of the Board of County Commissioners, so a 100% inclusion, plus the treasurer and the clerk of courts, all elected under both scenario, all independently elected. Under our charter, our Investment Advisory Committee is comprised of the treasurer, the council, a member of council, and the executive. Once again, that appearance of undue influence through the treasurer being an appointee of the executive exists. It's along the same concept we just talked about with the two previous topics comprised in 0164. So what the intent here is to change is the composition of the Investment Advisory Committee. Since the county treasurer is the chief investment officer of the county, it's prudent that the county treasurer, in my opinion, as the author of this, remain on the Investment Advisory Committee. A member of council, which right now is Councilmember Schron. The previous first 2 years it was Mr. Miller, and the prosecuting attorney as the only other elected official of the county to which there's not this appearance of a conflict. That is in looking at this, there's some other provisions in here. Two other provisions would basically is that the duties and powers and the investment policies of the Investment Advisory Committee will be approved by council. The belief there, my thought there is, we are talking about the Investment Advisory Committee right now, and although they're very strictly mandated as to how they can invest in the county's money, sits on about $830 million worth of county money, nearly, closer to a billion than half a billion. And council, as the fiduciary body of Cuyahoga County, has no input into those investment decisions like a statutory county would. And I'm okay with that, insofar with these provisions that are in there, meaning that we would have an opportunity to vote on the rules and procedures as well as the investment strategy of the county and changing the appearance of the independence of the board itself. So that's the proposal before us, and I'll entertain any discussions. Mr. Brady?
Chairman.
Yes, I'm sorry.
Perhaps you, or perhaps Mr. Miller, or perhaps Mr. Schron, or anyone else might be able to help me give me a better sense of the sort of a succinct sort of, what is the extent of the authority of the Investment Advisory Committee? How would you describe its actual authority besides what appears to be in its title, an advisory committee?
Sure, and I'll defer to Mr. Schron, the current member, and then Mr. Miller as the former member.
Yeah, and I think it's a great question because it does bring into both, there's the philosophy of the investment policy, and then there's the actual physical actions of investments that take place, and just make sure that keeping those as separate concepts. The philosophy, and if you go back and read some of the early documents that came out from the charter review, or excuse me, from the folks who worked in the charter, it was to eliminate all foreign investments, because at that point there was some real controversy going on into what was the condition of the euro and what was happening with funding across the world, and it was a desire to take us out of all foreign investments. The policy of the Investment Policy Board was not to follow that recommendation if there were legitimate, good places to be investing, and we have invested in foreign currency and foreign bonds in the past. Yeah, because the yield has been good. The Israeli bonds that we bought into, it's capped. It's a very tight control, but we did not follow that. So that was the policy of putting in place. The actual decisions as far as what goes forward, we do have professional recommendations. They actually do that. We're not sitting there deciding, buy this stock, do that, invest in any kind of vehicles like that. That's what we do receive third-party investment. So fortunately, they're giving us the recommendations. They're giving us the building of the portfolio. The big change that came forward, as you recall, this year, was it this year? Oh, it seems so. Within the last year. How about we'll do that? I can't. It's all getting kind of a blur at this point. But the idea of us in creating a new investment pool to go into neighborhood, maybe it was either schools or communities that were having trouble getting their bonding, that we would go in and help support that through funding. That's a philosophy. The decisions as to city X and city Y, one's good and one's not good because we don't think that's a decision on an individual investment. I hope I'm making it clear as far as the philosophy was to go into this new vehicle. The actual decision to choose community A or community B is not something that this board actually does. So we set the policy. The responsibility has been augmented to a third party to actually do the review of whether or not this is a good place to be. Is the security there? Are they going to pay the debts back?
That's quite helpful.
There's two different components.
Yes, I sort of assumed there was,
But let me just finish,
okay.
just briefly on that. Let's assume that the idea, and the idea was a combination of the county executive wanting to go into these communities and my idea to go into schools. So together we ended up with this philosophy. But let's assume that, that I resisted the whole concept as representative for this council. The likelihood is that the treasurer was potentially could go and fall in line with that philosophy, and we would not really, there wouldn't be an independent third voice. So it says, let's go into investing in communities and being a backstop for that. We as the council don't like the idea. An independent body maybe didn't like the idea, but it could have still gone forward under the current structure the way it is in place. If you know, if you don't have the checks and balance in there. So that's hopefully give you some background on it.
Thank you.
And Mr. Miller respond as well.
I would add that I actually think the term Investment Advisory Committee is somewhat of a misnomer because under the state law, the Investment Advisory Committee is not advisory. It sets the policy of what you can invest in and what you can't, subject only to that it has to be consistent with the State Uniform Depository Act. The second thing that the Investment Advisory Committee does is that it hires an investment advisor and a review is done on a quarterly basis as to what's going on in the financial markets and how the county's portfolio is performing and whether it's consistent with its benchmarks and such things. So, to my mind, as important as the question is as to whether we should change the structure of the Investment Advisory Committee, I think the biggest thing in this proposed amendment is item 3, where it says that the establishment or amendment of county investment policies by the Investment Advisory Committee shall be subject to the approval of county council. With statutory counties, it's somewhat of a moot point because 2 out of the 3 members are members of the county commission, and so it's essentially the same. The county commission runs it; they just do it through the Investment Advisory Committee. But with our form of government, it's a really significant question as to whether the county council through the legislative process should play a role in determining investment policy and whether under home rule we could do so. And this amendment clearly makes that change and gives the county council a role.
And just further to that point, and Mr. Miller touched on it, and I touched on it in my introductory comments, in a statutory county, you have a majority, if not all, of the county commissioners effectively making the same decisions. Some of us have served on city councils, and city councils, the council members, the council themselves, I know in the city I served on, I know at least one that I represent, all members of the council serve on the Properties Committee as well as a separate, I don't know if it was like that in Parma and Strongsville. So you effectively have the same members on the council serve on a separate committee making decisions on behalf of the county. Here, we don't have that. We're actually different from the state, from statutory counties, the other 87, where they're a majority, if not all of their members, depending on the composition of their investment advisory committee, are making those decisions. We don't have that same level of input other than through our one member, since we don't approve the rules and the policies and the procedures and the investment strategy. So we actually are, as a body, in a lesser position of exerting influence and making decisions on $830 million worth of investments than a statutory county, or even in the relationship I just described of a city with its property committee, even in that environment. We could take this one step further if there's concern. I may hear some moans as a result of this statement, but if there's concerns about our ability under home rule to to approve the rules, policies, and strategies of the Investment Advisory Committee, we could strike this out altogether and make all members of council members of the Investment Advisory Committee or the Finance Committee, plus the treasurer and the executive, so forth, to serve on the Investment Advisory Committee. I'm not necessarily advocating that, but if it does come down to a situation where it's determined that we cannot, as one body in this environment, set the rules, policies, and procedures of another, then maybe we should look at council, either Finance Committee or the council as a whole, with the executive and the treasurer serve on the Investment Advisory Committee. Just throwing out a couple options if we run into one obstacle. But I think it's important that the composition, number one, change because of this appearance of a change of undue influence. It is important because we are the fiduciary stopgap to the county, yet we have very little input into how $830 million of taxpayer dollars is allocated. Two different concerns. So that's why I brought this forward. Any discussion or any?
Mr. Chair, well, what you have proposed, it appears, is to add the prosecutor, replace the executive member with the prosecutor? Am I reading that right?
That is what is in here. That's obviously subject to discussion. The reason is whether it be the treasurer, the belief is the treasurer is the chief investment officer must serve on that committee. Since the prosecutor by our current charter serves on the budget commission, there's already a precedent set by that. And that's why I put that position in here. It's also the only other charter elected position, meaning the treasurer is a representative of the executive. The council obviously is elected and the prosecutor is elected as well.
Okay, well, I'm just going to put it out there that I'm not comfortable at all with adding the prosecutor to this mix, and comfortable with the constitution right now of this Investment Advisory Committee, and council has its 1/3 voice at the table, and certainly the prosecutor is not going to add. I think it's going to actually be problematic to have the prosecutor on this particular board. So those are my comments.
Okay, I'm going to just ask the question. I got Mr. Shaw next. Just ask the question, why is it the belief the prosecutor would be less qualified than an elected, and I'm not getting personalities involved, but why is it the belief that the prosecutor would be less qualified to serve on the Investment Advisory Committee than an elected executive?
Well, we'll give the example of the investment in the infrastructure, because that's what this is born out of, I believe, because when this particular committee made the decision to invest in our communities, I remember that at least one council person was opposed to that and had an issue that the council wasn't able to weigh in on that particular decision. So I think, first of all, this comes out of that situation, and I think the administration needs to somehow have a voice, a strong voice, in what policies and practices it's going to be implementing. I mean, this was a program that it's going to end up administering. So when you have a third-party prosecutor who really has no understanding of what the programs are going to consist of and how they're going to be implemented, I don't think it makes any sense whatsoever to have that particular individual serving on this, and it just doesn't make sense. And I think because of the connection between the policy and the implementation of those policies, it's important to have those who will be administering the programs to have the seat. But the prosecutor, has really no connection to that which this administration is going to be, or council is going to be processing. So that's my concern. And if we look to the past at the prosecutor's role and some of the decisions that were made in the past in this commission, and it's not personalities, it just didn't make sense. I mean, we're looking at some of the decisions on the Mayor Trust purchase way back when, and when you have somebody disconnected from this branch of government, I think it's problematic. But I think it's important to have the executive administrator sit on this board because they're going to be there. They're going to be involved in what's happening, and that doesn't take away from the objectivity of the whole board on how to invest. So those are my comments.
Thank you, Mr. Chairman. I see the investment policy board, and I agree with Mr. Miller that it's more of policy than, as I indicated in my comments, than it is actual action of decisions. In our own personal lives, we'd be making decisions on how we individually invest. This board does not do that, and it should not do. And I see it closer to what we just discussed earlier in the internal auditor function, in that the value for an investment board is in bringing knowledge to that scope. And so therefore, it should be the most knowledgeable people we can get in there. I understand your desire to have the review of the policy, but assuming that we've had an input on who's on the board, the policy, what I've seen in other investment policy boards is the decision within the policy board, assuming they stay within the scope of certain limitations with their, which is all held under statutory. It would be my suggestion that you actually follow the same model that we're talking about doing with internal auditing, that getting outside expertise on the investment policy board to help set that, as opposed to going the other way around, leaving the treasurer, the one counsel, and then either 3 members from the community to be part of that. And I've seen that being on investment policy boards that I sit on, where you're actually using the expertise, just like we're using expertise on internal auditing to use folks coming in to be part of that internal audit team to bring their auditing knowledge. Here we bring in people with investment knowledge out there. And so the executive can have a role because he brings forth the names of individuals that would be from the community that would bring investment knowledge and basis out there. And I think they could play a role in that responsibility to amend it accordingly too.
Very good, thank you. Mr. Miller?
Mr. Chairman, I'd like to really thank you for bringing up this amendment, because the whole question about whether the council should play a process in setting or reviewing investment policy is one of those structural questions that really kind of cries out for resolution after we set up this form of county government. And I know the Director Majid has done some research as to how much power we may or may not have under home rule to either change the structure or to have the council play a role in the investment policy. And I'd like if the law director could share where he's at on these questions.
Sure.
Thank you. Let me just sort of say the following, and I'll get it, because I think I may have an alternative that you actually may like, which is if you think of how it structurally works, and think of a simple administrative law, 101, you have the legislative body enacts the law and enacts the investment law. Then you have the agency that promulgates the regulations under the law, basically, and then you have the administrative officers who carry out the law as interpreted by the regulations. And this is really how this works, is you have the law. The issue with the law is the problem with it is established by the General Assembly, by the State General Assembly, but the law in terms of the categories of investments and what we can invest in and what we can't invest in is established by the General Assembly in what's called the Uniform Depository Act, defines what we can invest in, what we cannot invest in. The Investment Advisory Committee then, within the confines of the general law, they go in and sort of what we call the policy, but basically enact the limitations, the policy, but it's within what the General Assembly has already told them to do. And then within that, we have the treasurer that does the investments. There is no bigger advocate of home rule than I am, and I think this council has witnessed it repeatedly. There are areas where I become very sensitive. I cringe when it comes on home rule, which are areas sometimes when you're talking about real property, you're talking about issuance of debt, investment, things of that nature, because those are really issues of not just statewide concern. I mean, when you're talking about investment and debt, that's federal, a lot of this stuff is very regulated. So I was always starting from the presumption that we can't deviate from the Uniform Depository Act because that's just an issue that's established by the general, that we wouldn't have the ability under home rule to deviate from that. We continued researching it, and we found an Attorney General opinion. Now it's mentioned in what's called dicta. It's not a holding of the opinion itself, but basically that says that absent a charter provision regulating the investment of public monies of a county, the investment of monies in a county treasury is governed by the Uniform Depository Act. So it's almost pretty much saying that if you have a charter, you may be able to deviate from the Uniform Depository Act. Again, an Attorney General opinion is only as good as the ink and paper is on it. It doesn't hold any weight or anything. It's just an opinion. That's all it is. It's not a court opinion. But we started looking to other entities, how they do it, because I know we're always confused because we're looking to other counties. But the very point of the charter was to deviate from that structure and to really adopt the municipal structure. I mean, that's the whole idea of the charter, is to establish a legislative branch and an executive branch and delineate what the executive does and what the council does. And if you think often, sometimes I would caution council even sometimes is, sometimes you may think that you have more power by placing council in a lot of the administrative decisions, but what you're eventually doing in the long term is you're harming council's oversight functions, because now you've become part of the decision-making level at the lower level, and then your oversight functions, over time that actually, even though it's perceived as shifting power one way or the other, over time you're actually limiting council's oversight powers because you're too involved in the very decision-making that you're supposed to investigate after the fact. But based on this Attorney General opinion, and if it happens to be correct, and I say that with a lot of trepidation because of the area of the law in which we're talking about investments and things of that nature, and really we're playing with fire. I mean, we're talking about $800 million worth of money. This is not like the Board of Revision, what's the worst case scenario if we got it wrong? This is something, if we got it wrong, the consequences are very substantial. I think if council is compelled to do something at this point, would be prudent not to rush to make the decision in this charter amendment, because we'd be stuck with it for a long term to come. If we want every change in the investment policy to be approved by the council, if you have a crisis and you need to act right away and it change, you're taking away the ability of the people who need to make the decision to make it promptly, to make it. I mean, when Lehman Brothers collapsed overnight, I don't know if we needed to do anything of that nature, but you need to provide the flexibility to the people who are making those decisions to be able to react instantaneously. And as innocuous as it sounds in the sense of that the policy change needs to be approved by council, I really worry about the consequences. I know in the last 3 years they only changed it once. I'm not worried about the day-to-day changes that need approval by council. I'm worried about the things that we can't even anticipate and the need to react instantaneously when we can't anticipate. So my thought process is, if council wants to do something, is absolutely determined that they want to do something about this and they want to do something about it now, what I would do is in section 3.09 of the charter, which delineates the powers of the council, instead of deciding what the investment advisory committee is now or anything of that nature, what you would give the power in section 3.09, you would say to establish by ordinance the laws and procedures governing the deposit and investment of the county's monies, including the general classification of eligible investments and the ability to reorganize or reallocate the powers and duties of the Investment Advisory Committee prescribed by general law. And if you look to, for instance, how the city of Cleveland operates right now, you look to their code, their county code, they actually have in the investment laws, not the policies, the investment laws, which are almost like the Uniform Depository Act. They have it in their code, which gives me a little bit more comfort that maybe there is a precedent for this, that we really can deviate from general law in those areas. And then what their code does is it makes the finance director the entity who sets the policy, the regulations. So their investment advisory committee is their finance director, a single individual. And then you have the treasurer who invests those. Again, that's the structure that Cleveland chose by ordinance to do it. That may give council the flexibility to, one, you make it clear that in case if we have the power to deviate from the Uniform Depository Act, we can do it. We establish our own depository and investment law locally. You establish the procedures for it. You have the time and sort of you can really vet this out, take months in terms of what is the best structure. Do we even need an investment advisory committee, or is there a different structure that makes better sense for the county? And then you give yourself the flexibility to do it. And if you got it wrong, you have the ability to amend the law and get it right the next time. The second, when we put something on the charter and we can only put another charter amendment on the ballot, not until the general election, we can't even put it in a primary or call a special election or anything. We have to wait until the general election. These are, when you're talking about investment, these are sensitive issues. So those are my thought on this area. As your own lawyer, as your own counsel, I would caution you to be very careful with these investments. I mean, the consequences are too severe, and it's when we really least expect it, when this can come back to bite us. If you want to do something, give yourself the flexibility to do it by law later through local legislation. Then you can address the things later by local legislation instead of fixing these things in the charter itself. Those are my thoughts on this. But
Thank you for that. Any other comment? Okay, so let me just to be very brief, it appears there's going to be at least one amendment to this section of this, or actually to this resolution. This one is a single subject resolution. We have less control as a legislative body than 87. I don't know how Summit County does it. Than 87 statutory counties as it relates to investments of the county, and that was by design in this charter. That's a fact. So the question comes in twofold. Number one, do we believe that there's a possible appearance of a conflict of interest and a perceived undue influence between one employee reporting to another that make up a majority of a board, which is what's in this one? And do we believe that we should have more input into the investment decisions and policies of a board to which 87 other counties have that authority? That's what this boils down to. So, not to continue to belabor the point, I know there's an amendment coming to this one. There's an amendment coming to the previous resolution from Council President Conley. We'll hear those on the 17th, which will give us time and our staff time to prepare the amendments. I believe Mr. Germana, were you motioning? When you're done. Okay. Well, all right. Well, Mr. Germana and Mr. Schron, and then we'll move on to the next one.
I don't know how to say this politely. I'm going to be voting against this because, you know, this idea of this influence, I think it's the appearance, but I don't really think we have that appearance because, you know, just in the last 2 weeks we had an appointment that may not have been approved by council, withdrawn by the executive. So these are not just casual employees that have influence. These are people that are vetted by council, and if we carried this to the extreme, any place in the in the charter where the council president appoints someone for some kind of committee, is that influence or the appearance of influence? I think we're carrying this too far. And, you know, putting the prosecutor on this just because, and it should be the executive and the treasurer. So, and I think, you know, the citizens of Cuyahoga County have seen that, hey, these people that the executive appoints are going to be vetted and they're going to do the best job. And there is a certain amount of independence because they just can't wholesale fire them. Because there's people looking over the shoulder. So
Thank you.
I hope I said that politely.
Sure. Mr. Schrod?
Yeah, I guess just to Mr. Germana's point, I do see a significant difference between an appointment that once the appointment is done, you no longer have contact, and sitting next to the same person that you are actually reviewing in a decision-making capacity. So I have no problem seeing a distinction between those two. But I just ask you to, this board to, this council to think about what if you would have disagreed with the policy change, though I agreed with it. If all of us would have disagreed with that policy that we just implemented, and you would have had no other checks and balance, and I just ask you to replace that policy with a coin scandal from a number of years ago, and if the policy would have been to invest in those, as it was by an investment policy board prior to that, and the two decision makers on that same one reports to the other, where would your attitude be? And I'm not asking to make that decision today, but I'm just saying, look at it, what would you have done, and what would your checks and balance be out there? So I throw that out there only as a comment. More, I understand what Mr. Greenspan's trying to do. I'd love to find a solution that someplace eliminates that, where in our own company, a superior cannot have a subordinate in a spousal relationship and an appointment relationship or anything of that nature. And in this particular case, I understand what Mr. Greenspan's doing. I think there would be a way in which we could structure something to take that superior subordinate sitting at the same table relationship out on an actual board.
Mr. Chair?
Sure, Ms. Simon.
This is going to take time to flush out. I don't think we need to rush into this. There's no emergency, there's no urgency, there's more important amendments. I understand what this is born out of, and I don't want to see anything rash happen because of an investment decision that a council person disagreed with, but I understand the potential. Perhaps council wants to look at this, but we need time to do it, and I don't think rushing to the ballot with this makes sense. This needs to be flushed out, and it needs a lot of work, and it needs a lot of, in just terms of research. So I think we need to put this on the back burner instead of making amendments. When I see the prosecutor on this board, that, you know, that's something that was just thrown in because it was someplace else, and it's just really not a sound amendment.
Let me just make this statement because you've made reference to this multiple times. I understand the inference as to where this was born out of. This was born out of an incident that occurred in relation to the money that Mr. Schron spoke of for communities and now schools. True, but this was born out of that action and review of the composition of that board and the further review of our charter to eliminate that perceived appearance of an influence. That's all I'm going to say on that. I'm not going into more detail, but I'm not going to sit idly by and allow a comment to be made with an inference beyond that. The clerk will please read the next item, item 160.
Resolution number 2014-0160, A resolution providing for the submission to the electors of the County of Cuyahoga an amendment to Article 2, Section 2.01, and Article 3, Section 3.03 of the Charter of Cuyahoga County, modifying the residency requirements for the offices of County Executive and County Council, and declaring the necessity that this resolution become immediately effective.
Thank you. Mr. Miller?
Mr. Chairman, my colleagues, I'd like to thank councilpersons Conwell, Germana, and Gallagher for co-sponsoring this resolution with me, and also recognize Ms. Conwell for the suggestion that the two residency-related proposals be combined. This resolution combines the Charter Review Commission's two amendments dealing with residency requirements for executive and council into a single amendment. Other than combining them, the language is exactly as unanimously proposed by the Charter Review Commission. Currently, candidates for county council must have been an elector in the county for the 2 years immediately prior to filing as a candidate, but candidates for executive need only to be an elector at the time of the filing. This proposal amends Section 2.01 of the Charter to make the requirement of 2 years residency prior to filing apply equally to the county executive. Being the higher office, the county executive should meet an equal residency requirement. Note that there is a technical error in the presentation. The word "be" crossed out should appear before "have been an elector." Regarding council members, Section 3.03 of the Charter currently states, once elected or appointed, council members shall reside within the county, and members elected from districts shall reside within their respective districts during the tenure of their terms. This language could place a council member in violation of the Charter simply due to redistricting and disqualify a member from serving half of a term to which the member was properly elected. Suppose a council person is elected in 2020 and the boundaries are redistricted for the 2022 election so that the member no longer resides in the district from which he or she was elected. When those districts become effective in January 2023, that council member would be in violation of the Charter and could be disqualified from serving the last 2 years of his or her term. This resolution proposes to amend Section 3.03 to say that council members shall reside in their district during the tenure of their terms, except that a council member will not be disqualified from serving their full term due to redistricting. The amendment only applies to a term to which a member already has been elected. In the situation described above, if the council member wanted to run for an additional term from the district from which he or she was originally elected, the member would have to move back into the district at least 30 days prior to filing in order to meet the Charter requirement. Because the first redistricting that we did took place only 2 years after the start of the new government, the Redistricting Commission rightfully made only modest changes to the boundary while meeting population requirements. But with 10 years separation in the future, boundary changes may need to be more significant, and this amendment is likely to be needed. This amendment makes two needed changes, and I ask for the support of my colleagues.
Very good, thank you. Mr. Brady, and then any other comment?
Thank you, Mr. Chairman. On both counts, this seems to be, well reasoned. I suppose, my real, thoughts are, although it's not something I care that much about, that if someone moves in to a district or out of the county and the voters choose to elect them, I don't see the problem because the voters are the ones who decide. But, I don't have any real objection to that, particularly if others want there to be those kinds of restrictions. And I think the second part with the redistricting is very well. It's very well thought out, and is something that does need to be dealt with. It's just that, given, and this will sound like 2 years ago, given the number of charter amendments that we decide to put on the ballot, worrying about the redistricting of the next decade, and with so many opportunities to do something about that between now and then, I don't see the urgency to that part of this proposal.
Very good. Mr. Schron?
And I agree with my colleague, Mr. Brady, on this. In spite of the charter having written limitations in here of length of living in a community, the voters ultimately make a determination as to who they want to represent them. And I mean, you don't even Congress, you don't even have to live in your district. So here we are trying to create a rule that says if somebody moves from one district to the next, theory on this piece of paper, if I move from my district over to your community because I wanted to move into a different lifestyle or something of that nature, I would now be ineligible under this, even though I just got done serving 6 years. I'm not even a fan of any years of service because the voters ultimately determine whether or not you're qualified and the years of service. So not only am I not in favor of it for the county executive, I'm not in favor of it for any of these positions, because why is somebody more qualified because they lived there for 2 years in the eyes of the voter? As Mr. Brady said, the voters ultimately make that determination.
So just as a matter of reference, right now the charter refers to a council member must live 2 years in the district and 30 days, 2 years in the county, 30 days in the district prior to filing. The executive has nothing. So just as a point of reference. So President Conley and then
Yeah,
Mr. Germain.
I feel very strongly about the section that requires a 2 years residency for the county executive. If all of a sudden Jerry Springer decides that he's going to run for county executive, and he's got a popular name, he comes in and never lived here, doesn't have anything to do with Cuyahoga County, and then all of a sudden decides to move in, and I just think that we need to prevent that. I pick out Jerry Springer because I couldn't think of another name, but some guy named John Glenn moves here, not the John Glenn, but some other guy named John Glenn says, I want to run for county executive, and people get confused. So I think that the 2 year requirement for the county executive is very legitimate.
Mr. Germain?
If you take this last election into consideration, in my district at one time, I had 4 cities. I had Brooklyn, Seven Hills, Parma Heights. Now, the people of Brooklyn and the people of Seven Hills elected me as their county council person. Now, there was a redistricting. Brooklyn went to my colleague Dan Brady. Seven Hills went to my colleague Jack Schron. But they weren't elected by those residents. So it's kind of like representation or yes, whatever. They didn't vote on them. They didn't vote on them, and they inherited them. So that's one situation. Now, the other is if there is real need to redistrict, but the redistricting is going to affect a council person being out of the district, there's going to be a hesitancy to redistrict for the right reason, because you're going to be redistricting a council person out of that position. And I think the redistricting should be done on common sense, based on population and whole cities as much as possible. So what this does is this accomplishes that. So That's the reason I'm for that. It's the people get the representative that they voted for, and then the next election, they can decide, you know, who they want.
Very good, thank you. Ms. Conwell?
Yes, Mr. Chair. On the first part of this amendment, because I think Councilman Germano was talking about the second part, but on the first part, I have to believe that that part of the amendment originated to hold the executive to the same standard as county council. And I have to agree with Council President Connolly. I think you have to be invested. 30 days is not enough because you may have money or whatever the case may be, but I really think that you need to be vested and know what's going on with the county and to actually live here and decide, you know, if that's something that you want to do instead of just making a name for yourself. As far as the second part, I mean, I think it makes sense to put these amendments together since we are limited on what we need to place on the ballot and the cost. To Germana's point, it's something that's not going to really be determined for 10 years down the road, but I think we do need some protections in place. So I'm okay with the amendment. Thank you.
Thank you. Any further discussion? Mr. Boyle, briefly?
Very briefly. Again, hearkening back to the actual charter review process that went through with the Charter Review Commission, both of these matters did come before that entity, and I think it is appropriate to recognize Councilman Miller as it relates to the potential for the issue arising with a gap between redistricting. That's a very real one, and Councilman Miller and Councilman Brady, who served in the state Senate, that's one of those situations that has real applications, and I do think needs to be addressed. As it relates to the issue relative to the executive's residency, with no fear of contradiction, and Mr. Tartar is here as well, I really believe that was an oversight of the drafters when the charter was put together, the failure to include a residency component for the county executive. And I certainly understand Councilman Schron's comments about, you know, the voters have the right to do it. I believe Congress is the only entity, elected body, that allows people outside the district to represent them. And so that's really the anomaly rather than the rule. And as it relates to this, the concept that others can come in with a bag full of money and with a good name and can buy their way into this position is not one that I think we should think is so far-fetched. And with that, I do think it's important, and again, on behalf of Council or Executive Fitzgerald, this is something that I think is appropriate and mandates that the individuals that are going to run for the position of county executive have a connection in the county, more so than just being an elector at the time of the actual election. Thank you.
Very good, thank you. Any further discussion? All right, hearing none, will the clerk please read 0162 to the record?
Resolution number 2014-0162, a resolution providing for the submission to the electors of the County of Cuyahoga an amendment to Article 12, Section 12.09 of the Charter of Cuyahoga County, accelerating the timeline for the appointment process and commencement of the term of the Charter Review Commission for the year in which the appointment is made, and declaring the necessity that this resolution become immediately effective.
Very good. Mr. Miller.
Thank you very much, and I'd like to thank Council President Connolly and Councilpersons Conwell and Germana for co-sponsoring this resolution with me. This resolution deals with the appointment of the Charter Review Commission itself and is an amendment that originated within the Charter Review Commission itself. The amendment deals with the fact that the current charter language does not provide sufficient time for the council to properly review charter commission appointments and get the commission started on time. This resolution corrects that problem by requiring that the executive's appointments for the Charter Review Commission be sent to council by June 1 of each charter review year, rather than sometime during the month of September. This amendment is exactly the same as unanimously approved by the Charter Review Commission, except that it incorporates Council President Connolly's suggestion to require the executive appointments by June 1 instead of July 1. If there are clear issues with the appointments when received, the council could send them back to the executive to be reworked for up to 30 days, and we would still have the full 60 days for the confirmation process before the Charter Review Commission starts on September 1. The Charter Review Commission strongly and unanimously believed in this amendment, and I agree that it will lead to a much better appointment process and start to the Charter Review Commissions. And I ask my colleagues for support of this amendment. Thank you.
Thank you, Mr. Miller. Mr. Brady?
Thank you, Mr. Chairman. I agree with the proposal, as with the previous one. It's well thought out, particularly the second part of the previous one. But again, although not as not to the extent, because the redistricting is quite a distance off. I still don't see the urgency to this proposal, and I think that these kind of proposals resonate better with the with the residents, with the voters, when they are closer to being a decision that they feel like needs to be made. And I don't think this is a decision that needs to be made in 2014. Okay, and also, I'm always trying to keep us from putting too many charter amendments on the ballot.
Mr. Chairman.
It's a good proposal.
Mr. Miller?
Mr. Chairman, I would just like to offer that that I think this amendment is a little more timely than it might first appear, because the next Charter Review Commission is in 2017. And so we have 2014, and as for next year, 2015, that's a year in which we otherwise don't have elections, and where the election costs would be much higher, and we very well may not choose to put any charter amendments on the ballot in 2015, which would bring us to 2016, which would be the only other shot before this becomes relevant. And I don't know that I would want to leave it to just a single shot, because it may be that in the general election of 2016 that there's other things that rise to greater importance, and it will have been good if we had gotten this item out of the way. So unless we really have a crowded ballot developing for 2014, I think that there would be good reason to submit this one this year.
Okay, very good. Any further discussion? Hearing none. The clerk will please read the next resolution. 0161.
Resolution number 2014-0161, a resolution providing for the submission to the electors of the County of Cuyahoga an amendment to Article 5, Section 5.01, Appointment and Confirmation of Officers, and Section 5.08, Sheriff, Powers, Duties, and Qualifications, establishing the term of appointment and process for removal of the sheriff, and declaring the necessity that this resolution become immediately effective.
Very good, thank you. As a sponsor, I'll address this one. This item has three fundamental provisions which are represented on the second page of the resolution, under section 1, numbers 3, 4, and 5. So I will address those items in particular. This has to do with the sheriff. The first item basically states that the sheriff shall be appointed for a 4-year term, and the intent here is for that 4-year term to be staggered with that of any executive. So whereas an executive term, and we'll use the relevant term coming up, will begin in 1/1/15, the sheriff's term would expire at 12/31/15 and begin effectively on 1/1/16. So the sheriff would always, their sheriff's 4-year term would always be 1 year after that of the executive. The removal of the sheriff is the second provision. The removal shall be effectively be in the same order as the confirmation of the sheriff, meaning a recommendation by the executive and confirmation by 8 members of council. I would imagine, and I'll ask the law director, although not in here, since that is an HR matter, that would be a matter discussed in executive session. Would that be a correct assumption?
The charter amendment itself?
No. In the event of the request for removal of a sheriff, would those discussions be held in executive session?
That becomes a personnel issue.
Okay, very good, thank you. The last item simply discusses the vacancy of the sheriff, should a sheriff vacate in the middle of a term. And basically what that says, if the vacancy is less than 2 years prior to the expiration of a 4-year term, the executive may appoint a sheriff to complete the unexpired 4-year term. That's basically what this is. This is a holdover from 2 years ago, or from last year. I'm not aware that we've made any philosophical, well, I take that back. The concept is a holdover from 2 years ago. Any discussion? No discussion?
Mr. Chair,
Simon?
silence I can fill. I'm not comfortable with I wasn't comfortable when we looked at this the first time, and I'm not comfortable with it now. I think the charter has it right that the sheriff should be under the executive, and so I think I'm not comfortable with the changes that are here.
Very good. Ms. Conley?
Yeah, I disagree with Ms. Simon on this. I believe that the sheriff is an independent officer. He's like the internal auditor, the inspector general, that he or she has a function to serve. And certainly I'm not referring to the current executive, but, if the sheriff started investigating something that the executive didn't like, then all I can say, you're fired, you're gone. And I think that's totally inappropriate. The sheriff, the tradition of the heritage of the sheriff is a very, very important function in the county, and that person should be independent and be able to make decisions without having to live in fear that he's going to be just walked into an office one day and said, you're gone. So there has to be, don't look all shocked, Mr. Boyle.
Well,
But I think it's very important that we have an independent sheriff that serves, if it's important, if it's sufficiently important for the inspector general, if it's sufficiently important for the internal auditor, it's clearly important that the sheriff had the ability to function within a given period of time. And, maybe like, where you want to stagger it, I'm not all hung up about that. But it should not be concurrent with that of the executive. There should be a carryover.
Mr. Chairman?
Mr. Schron, then Mr. Miller?
And I agree with the council president that I think that every place we can build in the appearance of cross-checks for the best interest of the public, where it does not affect the ability of the county executive, I don't think in any way to do their job. The county executive is bringing the name forward to us. This panel is reviewing it, and at that point in time, we have weighed in, and obviously, any of the members of the cabinet, including the sheriff, would serve at the pleasure of the county executive. But after we've already gone through the approval process, the person is sitting there. They're now doing functions that we wouldn't even want to know because perhaps they're doing, as you indicated, some investigative work. Could be investigating any number of different places within the county, because having just had some dealings with the sheriff's department in some investigative work, they do fantastic work, but you would not want to have any appearance that that work could be tainted or cut off in the process. And so I want to do everything we can to encourage that independence out there once that person has been appointed. And all we're saying is that we're gonna just weigh in on the loop. We weighed in on the loop at the beginning. Why wouldn't it make sense? And this panel here is going to be a supermajority before the person would get knocked off. So we're not going to do it at the whim either. And so it's going to be a very concerted effort. And I don't believe that this is going to come up it's not going to come up very often. If it comes up ever, or even once in a term of a county executive, I would be surprised out there.
Mr. Miller.
Mr. Chairman and my colleagues, I have concerns about this amendment, and I think that the office of the sheriff is very different from the inspector general and the audit committee in that the sheriff runs a very large department, one of the largest in county government, and one of the most fundamental things that the charter was trying to accomplish is that we're going to eliminate all these separate fiefdoms and allow the executive to manage a large operation and gain synergies and economies of scale in things like personnel and IT structure and such things. And if we set up this structure the way it's proposed here, the sheriff doesn't really have to answer to the executive, because it's no longer a direct line authority. And I think this would be the first charter amendment that we've proposed that would really undo some of what was that we accomplished in the charter, and I think what we've been doing has been working. I think it's not broken. So I have big concern about that. I also have some concern about if the executive asked us to dismiss the sheriff and the 8 votes were not available, and the executive had to continue to work with a sheriff that the executive didn't want. That also could create some serious problems. So I think we're better off leaving it as it is, and that there's certainly no urgency on this, and that we should give more time to see how well what the county structure provided, if that works to our satisfaction.
Great. Mr. Brady.
I think that this proposal, while not exactly what I or maybe any other member would have written by themselves, I know I've raised this issue several times. I think it has a lot of merit. I think the sheriff's office is different from other offices. A lot of counties that have executives also have elected sheriffs. If you talk to some people in some other counties, the idea that there's not an elected sheriff is completely alien to them. I've come around to believe that the executive appointing the sheriff is is appropriate under this new form of government, but I still believe that that there needs to be more independence built in, and whether it's exactly this or some other approach, I think that this is on the right track. That this particular office is different and needs to be insulated more as an independent department.
Very good, thank you. Mr. Germana.
I agree with this amendment wholeheartedly. I think, first of all, we're not going to have a politician appointed as a sheriff. It's going to have to pass this council. It's going to be a professional. The sheriff department, it's a paramilitary, the chain of command, and with that chain of command, you don't want to have any political influence in what's being investigated or not. And the idea of having 8 members of council that approve a dismissal really gives the sheriff some independence. And I can tell you that in my district, I got a lot of feedback from constituents when Sheriff Reed was dismissed, and I really couldn't tell them why. And what I heard is a lot of people said, well, the sheriff should have been elected all the time. Now, I don't agree with that, because we don't need a politician as a sheriff. We need a professional that has got a resume, it has got a history of leadership. As Councilman Miller said, it's one of our largest, most employees. And so I like the protection. And again, the new executive would have, after a year, could ask for a reappointment, or could ask to make a change. And that change would have to come before council. So I really like the protections in this, and I compliment you for this being well thought out.
Great, thank you. Any other? I just briefly, I obviously brought this forward, so I believe in the concept of what we're attempting to do here. Just as the Inspector General and the Internal Auditor have investigative authority, I would not like to see the sheriff begin an investigation and the sheriff removed because that investigation was too close to an executive. And that's why it's important, I believe, that we provide some level of independence and protection, but at the same time, there is the opportunity for removal as well. So I am supportive of this, obviously, as being the sponsor. Mr. Miller.
I just want to ask a question on that point, because I hear that argument all the time, but I don't see the sheriff in this role. I think that an investigation would more likely come from the prosecutor's office or the inspector general, and I would just like a little understanding as to when and under what circumstances the sheriff would be investigating the county executive or someone close to him.
Okay, and I just asked Mr. Schron, because I know Mr. Schron mentioned he had an experience with the sheriff's department, if he'd be interested in divulging some information, and so he has agreed to do so.
Yeah, I think that the concept of who they're investigating is not as relevant as what they're investigating, because you never know where that investigation might open what doors. And so you don't start with the worry that it's going to be investigating the county executive or any individual on this council. That's the idea of a nonpartisan, unbiased investigation. And I just recently, I know the sheriff has heard me congratulate he and his team, because we had an incident at our business, and they just did a phenomenal job of investigating and everything about it, and they didn't leave any any stone unturned, and that's their whole function was to get involved with that. And having been involved with criminal investigations and things with the CID in my military days, they were completely independent. They were part of the MP Corps, and they would investigate all the way up to the general. There was one in which they went all the way up to the general in charge of the base. And so you never know where the investigation starts. You never know where it stops. But the independence, I think, is what we're talking about here.
Mr. Brady?
Just that, I had an experience several years ago where, as Councilman Shawn said, it wasn't who was being investigated, it was just where the investigation led, and that investigation actually did lead into county government, but it wasn't intended to lead into county government. So that's right. It's not as if the sheriff's job is to investigate the county executive or something, and that's not really, I think, the point. Although I can, you don't know where an investigation's going to go.
Very good, thank you.
Mr. Chair.
Ms. Simon?
I can live with this compromise. I'm not in favor of the elected sheriff, but I guess there's some checks and balances here. I think their sheriff can't be standing alone and not having oversight, and this gives that to some extent. But those are my comments. I wasn't sure about the investigation either. Usually that's the IG or the prosecutor that would be coming into the executive or county government, but I can see how it might lead there, as Mr. Brady said.
Any other further comment from council? Mr. Boyle, briefly?
Just briefly, again, no, I'm not surprised, Council President. We've discussed this in the past, and so I'm glad that there is an ongoing discussion as it relates to this. One thing that I did note, that there is no, in paragraph 4 as currently written, there is no cause requirement. And so the commentary about answering questions about why a potential sheriff or in the future would be removed may not be germane if there is no public dialogue over the rationale for that individual being discharged. Oftentimes in municipal aspects, I think for council members or other members of staff, you have to file like formal charges of some sort indicating why, the reasons that the person's being asked to be removed from the office, and giving the other person the opportunity to be heard on that issue. In this situation, if all the discussions other than the vote would be behind closed doors, I don't know that there would be an opportunity for a public dialogue about the actual reasons for the discharge. And so the commentary from Councilman Germana about the reasons for a sheriff's discharge, in this current version, I don't know, unless there was a willingness to discuss it by the enterprises, that would necessarily be an outcome that would be guaranteed. The way I've read it, and what the law director's comment at the outset, that this would be a personnel matter conducted behind closed doors, I would make the assumption that the only thing that would be public based on that would be the recommendation for removal and the ultimate vote. And I don't know that, again, I know that we're in a dialogue discussion here. That may be something to take into consideration if this discussion moves forward.
Very good, thank you. Mr. Schron?
Just to comment on what we just heard, and I would agree that if Mr. Germano was asked the question and we were to participate, the only response I ever give is it's a personal matter. It's not to be discussed. But we were fully apprised of the situation, and we took a vote, and the vote would support it. So that by itself is a conversation that Mr. Germano was not at liberty to have. Not at liberty. I mean, he was not participating in it, and so I think it's very legitimate to be able to say, "I'm sorry, it's a personnel matter." That's why we are allowed under state law to have an executive session to discuss these kind of matters. And you can be assured, as your representative, that my vote reflects accordingly as to the right decision, as I believe it to be, or whatever.
Very good, thank you. Mr. Germana, do you?
I think that if there were some reasons that may be embarrassing to the sheriff and the executive asked for a resignation, then he could resign and use any excuse, and there's no public big furor over it. But if the executive wants a sheriff to resign because of inherent policy of feeling that the sheriff's going in the wrong direction, or who knows where an investigation is leading, and he refuses to resign, then it should be heard out. And like Mr. Boyle said, it's going to be an executive session. So I still like the idea of giving the sheriff this protection by having the 8 members of council having to find it serious enough for them to be discharged.
Very good. Any further comment? Mr. McClue?
Again, I just raised this as food for thought, not, I don't have any specific feelings about this thing, but think of whether the remedy is the right remedy, in the sense of, by having this term and the reappointment power, you could be almost incentivizing the sheriff not to get into areas that he should otherwise be getting into, because he wants to be guaranteed that they get the reappointment. You could do other protections, whereas you could outright prohibit interference with investigations, put repercussions to the executive if he were to interfere with investigations. There are other ways in which you could provide those protections, as opposed to the unintended consequence of, hey, I make peace, you make peace, you'll keep your job, you get reappointed. So I just raise it as food for thought for whatever it is. I mean, this is a policy question. It's not a legal issue, but whether the remedy is the right remedy.
Great, thank you. Okay, any further discussion? Okay, hearing none. Before we just move on further on the agenda, just to remind the committee, we'll be meeting again on Monday, the 7th at 1:30. The 3 items that we'll be hearing on the 7th will be the executive and Ms. Simon's proposal on the right to vote, the Inspector General proposal, and the, which is by Mr. Miller and myself, and Mr. Sharon's proposal on the removal of the party affiliation for elected offices. Those 3 will be discussed on the 7th. Today we had a number of amendments, proposed amendments coming, so I would encourage those members to work with Mr. King on those amendments, and to have them submitted to council for review prior to the meeting, so we all have an opportunity to review it. That meeting that we will entertain those amendments will be the 17th. And if the amendments are moved forward and adopted, I would envision on the 17th that us voting to move these items to referral to council. It only takes 6 members to refer it out of this committee, but it does take 8 to place it on the ballot. So just remind members of that. Is there any miscellaneous business before the committee? Mr. Miller?
I'm just wondering if you might encourage people who are ready with amendments to the first 5 items to also do those on the 7th if we have time. And if we did that, well, then people would have 10 days until the 17th to think about those amendments in their amended form and be better prepared to vote on them on the 17th.
I'm fine with that concept, as long as there's time at the end of the meeting for us to do that. So if we go through the items, the other ones we're here for 3.5 hours. Those are I would imagine, pretty lengthy discussion items. So if we do have ample time at the end of the meeting, I would be glad to entertain that. Ms. Schmatzer, did you?
Yes, Chairman Greenspan, it was my intent to distribute the next agenda as having all the items on them, so at your disposal, if you would want to discuss any of those items, they will be on your agenda, just to let you know.
Very good, thank you.
And then also, I just wanted to announce, we've moved over to the Outlook program, so I want to make sure everyone's calendar is okay for today, that the Health and Human Services Committee meeting is canceled, and that Education and Environment and Sustainability Committee is meeting at 2 today instead of 3.
Okay, very good. Any public comment unrelated to the agenda?
No, Mr. Chair.
Very good. We will stand adjourned until July 7th. Thank you.